Anybody know where that is? You ever heard of Lago Vista, Texas? I haven't, and I didn't look it up, but it's somewhere in Texas. But Texas is a big place, so I don't think it's a huge town because we would know of it if it was. So I don't know. Anyway, that's neither here nor there. But so the question in Lago Vista is the Fourth Amendment prohibit a warrantless arrest for a very minor criminal offense, such as a misdemeanor seatbelt violation, punishable by a fine. Does the Fourth Amendment give people the privacy not to be arrested if they violate the law that says they have to wear a seatbelt? You have privacy, the freedom not to wear that seatbelt under the Fourth Amendment. So Texas has a law that says if you're driving in the car, you got to have seatbelts. All the occupants in the car have to be wearing seatbelts. It's punishable by a fine between $25 and $50. So it's a minor offense, not a big penalty. In Texas law, expressly, which means that it's written out in very plain language and detail, that any licensed peace officer could arrest a seatbelt violation. So if somebody in the car is violating the law by not wearing a seatbelt, Texas law expressly allows that to happen without a warrant. Why would you say you don't need a warrant to arrest a seatbelt violator? What would be the justification for allowing warrantless arrest for a seatbelt violator?
It's putting people in danger and also like especially not if it's like a warrant the purpose would be to give somebody
Yeah, the reason we have seatbelts is they do prevent a lot of injuries. But also, there's this idea that when your seatbelts are in cars, motor vehicles, right? So if the police saw you driving without your seatbelt, and if the law made them go get a warrant before they could arrest you, you'd be gone, right? They wouldn't know how to find you. So although we do have nowadays, we do have telephone warrants, where police can almost instantaneously get a warrant through the over the telephone or whatever communication the device the police are using. Usually that's reserved for major offenses. So Atwater was driving her truck. She had her 3-year-old son and her 5-year-old daughter in the front seat of the truck. And nobody was wearing a seatbelt. So Officer Turek saw the seatbelt violation. So he made a traffic stop based on Texas law, which is perfectly legal. And Officer Turek and Atwater knew each other before they had an interaction before. And I don't think it was very pleasant. They didn't like each other. So Officer Turek said, "Oh, we met before." And he tells her, "You're going to jail." So he called for backup and asked to see her license and insurance. Atwater tells Officer Turek, "I don't have papers because my purse was stolen yesterday." Well, he doesn't believe her. He says, "I've heard that story 200 times." That's like the proverbial college student and professor, the dog ate my homework, right? I've heard that story 1,000 times. He doesn't believe her. actually, I had some student recently tell me, actually, my dog did eat my really swear. Does your dog eat paper? Yeah, some dogs do. Will chew on anything. Your cat? Yeah, my cat will bite me. Bite it. Your assignment is due at midnight or 11:59, and you got to turn it in on Black. There is a situation that you could have your paper assignment, let's say, and then you have to scan it into, let's say you have to scan it into PDF or something, and it's 11:56, and before you get a chance to scan the paper in, the dog eats your homework, and then by the time you get it printed again, get it scanned in and posted to Blackboard, it's like 12 o'clock. You missed the deadline by a minute. So I guess there is a situation where the dog could eat your homework or didn't you? But what's funny is that last night, so I have a friend who I nominated to be the alumni of the year for our college. He's a professor in Taiwan. He's been a professor for 35 years. I nominated him. The nomination deadline was Wednesday, 12th of February. So I had until 11:59 to get that letter in. So I'm pretty busy actually. So I thought, oh, I'll just write the letter last night when I got home about 7 o'clock. Well, I ate something and fell asleep in my lazy boy chair, and I haven't even started writing the letter, and it's like I wake up at like 9 o'clock. And so I hurriedly wrote the letter. My friend's from Taiwan. My wife is Chinese, and he sent me some of his materials in Chinese. I don't read Chinese, so my wife and I were desperately trying to decipher what I could put in the letter. In any event, I typed a 3-page letter. I had to proofread it several times, and by the time I got the letter written, and then I had to print it on the letterhead, and then I had to scan it in as a PDF on a little thumb drive, and then take the thumb drive and put it in my computer, and then send the email to the person who's in charge of the awards. I sent the nomination letter at 11:56 p.m. last night. So I was running around the house thinking, trying to get this thing done. So there is a situation where I guess the dog could actually eat your homework. In any event, he didn't believe when he said, my purse was stolen. He didn't believe her. So they were having this altercation, Turk and Atwater, and she's got a 3-year-old and a 5-year-old in the car. So the kids are upset, they're crying. So Atwater's in her subdivision, and she asked Turk, can I just take my kids down the road here to my neighbor's house? So, the kids are freaked out. He said, no, you're not going anywhere. But just unexpectedly, one of Atwater's friends drove by and stopped and said, what's going on? And they were explaining what was going on. And the friend said, well, I'll take the kids. So Turk did let the friend take the kids home to their house or wherever. So Turk handcuffed Atwater, put her in a police car, drove her to the station, booked her, where she had to remove her shoes, jewelry, eyeglasses, and pockets. Took a mug shot of her, placed her alone in a jail cell for an hour. Then she was taken to a judge and released on a $310 bond. So Atwater was charged with driving without a seatbelt, failing to secure the children in seatbelts, driving without a license, failing to have proof of insurance. police have those mobile digital terminals in their cars, and they have record of whether you have insurance or not. Did you know that? That the police always know if you have insurance or not. However, you as the driver under state law have to carry your insurance, that insurance card. And if you fail to do that, you can be cited for violating state law, even though the police know. So when the police walk up to your car and say, "Well, I want your insurance card," if you don't have insurance, they already know that, which I think is kind of silly that still have to carry the card. But the card is very handy if you have a parking lot mishap. You ever run into somebody in the parking lot, or you run, or somebody else run into you in the parking lot? Police don't want to come. That's not a high priority. Actually, little fender benders on the roads, police don't want to show up. They don't even want to write a police report. You ever had that happen to you? I have. And sometimes you have to demand they write a police report. Yes.
I think they're required to write a police report for any like car accident that they're called out to.
I didn't hear you.
I thought they were required to write a report on any time they're like called out to a car accident.
No. That's based on departmental policy, and maybe the department says they have to, but they don't have to. There's no law that says they have to. And sometimes they don't want to. And sometimes you have to really be, you have to demand it. And you should demand it because you're going to need that police report if you're going to file with your insurance. Because what will happen, one time I was really stupid, and this dude hit me in a parking lot. I said, well, I'm going to call the police, get a police report. And he was very persuasive, giving me his insurance and his address and his cell number. I even took a picture of his driver's license with my phone. But I never called the police and never got a police report. Well, when I filed that with my insurance, guess what? Guess what happened? He filed it was his insurance, and he said I was the one that hit him. And so the insurance companies then had to battle it out. I took the picture of his driver's license and sent it to my insurance company along with all the other information he gave me. But, the son of a bitch lied through his teeth, and that'll be the last time I ever do that. But, yeah, so get a police report, no matter how nice they are. And my wife was with me. I had a witness. I mean, she was my wife, so she would have reason to lie, but we would, based on, I guess, how credible we were. If I was litigious, I would sue him. Because he did leave a dent and a little bit of his paint from his car on my driver's side and back fender or whatever. But anyway, so Atwater pleaded no contest, no contendere, and she paid a fine of $50, and the other charges were dropped. So it went to the Supreme Court. But she's saying I was illegally arrested, illegally detained because it was such a minor crime. I should not have been arrested, taken to the police station in court. So Atwater, this is a civil case. Atwater sued under this statute, Title 42, United States Code, Section 1983. This law came about 42 USC 1983. We refer to that as Section 1983. mostly. Section 1983 is a federal law that allows anybody in the jurisdiction of the United States to sue a government agent acting under color of law. 42 USC section 1983 allows anybody in the jurisdiction of the United States to sue a government agent who violates their constitutional rights if that government agent is acting under color of law. So 1983 came from the 1871 Civil Rights Act. This is a statute that was written right after the Civil War. What was happening right after the Civil War was the Confederacy lost the war, as we all know. There was a huge backlash. There was a huge backlash in the South. Right after the Civil War, what organization was formed? The Klan, the KKK. The Klan was running roughshod over previous slaves and people who sympathized with slaves, and the local sheriffs, government agents in the Confederacy were not doing anything to protect black people who were former slaves and white people who sympathized with them. They were being lynched, they were being murdered, they were being thrown into jail, and the local government agents weren't doing anything to stop it. So the federal government says, well, the police and there were really no police back then, but we did have sheriffs and constables, we had prosecutors, we had judges, we had mayors. Actually, many of those people were the Klan. They were in the Klan. This person who ran the city may have been whatever, the chief wizard or whatever they call the head of the Klan. No, this is historically true. I'm not making this shit up. This is actually, you go read about it. It was awful. It was awful. So the federal government says, we need to do something so these local government agents will stop the Klan from, killing black people. So they passed this law, the 1871 Civil Rights Act, which is still on the books. Today it's called Section 1983. The 1871 Civil Rights Act allows people to sue government agents who violate their federal rights. So the idea of the law was that if a African American is victimized by the Klan, then they could sue in federal court to vindicate their federally guaranteed rights. Like the 14th Amendment was enacted right after the Civil War, and the 14th Amendment guarantees due process and equal protection to everybody in the country. So the 14th Amendment is being violated by the Klan and Klan sympathizers and, the white supremacy folks, which are almost most all white people, not everybody, but so this law survived until that's the historical justification for the law. And today it allows people to sue the police for violating your rights. So she's suing Atwater, saying Turek, is an asshole basically, and he should not have done what he did to me because that violated my Fourth Amendment rights. What is that right? To be free from unreasonable seizure. So when you take somebody into arrest, put them into custody, take them that's a seizure under the Fourth Amendment. And searches and seizures are two different things. They both have Fourth Amendment protections. So the city who's being sued, because Turk works for the city's being sued. She filed the suit in state court. The state court says this is a federal lawsuit. It should be filed in federal court. So it was moved to federal court. And then the federal district court said, well, she admitted she violated state law. So claiming that the Fourth Amendment was violated is meritless, meaning there's nothing there. There's no claim. Yeah, she said, yeah, I didn't have seatbelt. That's probable cause that you violated Texas law. You have Fourth Amendment rights in Texas, but if you violate Texas law, then the officer had probable cause to arrest you, which means that's not an unreasonable seizure. So they granted summary judgment for the city. That just means they decided, the U.S. District Court decided the case, the city wins. Now, that's appealed to the Fifth Circuit, because the Fifth Circuit covered this. That's the next. So the federal government trial court is U.S. District Court. The next federal court above the district courts are the circuit courts of appeals. We're in the Fifth Circuit. Texas, Louisiana, Mississippi is the Fifth Circuit. So Fifth Circuit, 3 judges reversed the district court, saying she really does have a lawsuit. And then the city asked for a rehearing by the full Fifth Circuit. There's only 3 judges decided this case. But the en banc Fifth Circuit, en banc is mean all the judges on the Fifth Circuit, so 12 of them or 13 of them reheard the case decided by the 3 judges, and they reversed what the 3-judge panel said. And they're saying that no, the city should win. So here, the district court said the city should win. The panel of 3 judges on the Fifth Circuit said no, she has a case. And the Fifth Circuit, all the Fifth Circuit, en banc, that's what en banc means, all the judges on the Fifth Circuit said no, the city should win. So then it goes to the Supreme Court. They granted certiorari. So the issue is the police officer's authority to arrest without a warrant minor offenses limited when states and cities enact restrictions. So the test is, what did the Fourth Amendment mean at the time of the framing? So they're going back and they're looking at this, original, what was the original meaning of the Fourth Amendment when it was enacted in 1791? So Atwater, the person who's suing, says the police authority to make warrantless arrest was limited for misdemeanors in common law. So in common law, police couldn't arrest everybody who committed a misdemeanor. That's her argument. She's saying that warrantless arrest can only be made for a certain kind of crimes, which is breach of the peace involving or intending toward violence. So this is like disorderly conduct, breach of the peace. She's saying you could only arrest people for warrantless. You could arrest a person without a warrant for minor crimes that involve disturbing the peace or breach of the peace or something that would tend towards violence. So she's saying the Fourth Amendment is very restricted. And then, so she's saying the founders would say what Turing did violated the Fourth Amendment because I wasn't disturbing the peace. I wasn't doing a disorderly conduct when I was arrested. So Justice Souter says, okay, and he says the founding rules, the founders and the other courts at the founding are not as clear as Atwater claims. So he says some courts allowed warrantless arrests. Other courts said you could only have a warrantless arrest for a minor crime of breach of the peace. So he's saying that in common law, that which is at the founding of the country, original meaning in the Constitution, that these courts early on in our country's history, they reached different conclusions about misdemeanor warrantless arrests. Atwater saying, no, there was a consensus in common law that you could not make a warrantless arrest for minor crimes unless it was for breach of the peace. And since I wasn't breaching the peace, I shouldn't have been arrested. Justice Souter says, well, it's not so simple. That it was some courts reached one way, some courts the other way on whether police can make a warrantless misdemeanor arrest. But Justice Souter says, since the founding, there's two centuries of state and federal practices that allows or permits warrantless arrest for misdemeanors, not involving breach of the peace. So Justice Souter is saying Atwater's argument is wrong. Atwater's argument is wrong because there was a lot of case law leading up to Atwater that allowed warrantless arrests for minor crimes where you didn't breach the peace. And today, all 50 states, the District of Columbia, and federal law permits misdemeanor arrests without requiring any breach of the peace. He said Atwater is all wrong. Her argument's wrong. And then he goes on to say the American Law Institute, and they're just that group of lawyers that comments on the law. And the American Law Institute says that warrantless arrests for misdemeanors, when the officer sees the crime, is fine. Is a good law. So Jeff Souter says, well, what the American Law Institute says about how police can arrest somebody if the minor crime was committed in their presence, they can arrest the person without a warrant. So that's what happened here. Atwater's post-op arrest treatment were merely gratuitous humiliations posed by a police officer exercising extremely poor judgment. What Souter is saying was, yeah, he had the right to arrest her, but he was being an asshole. But he could arrest her based on the law. And he was just trying to humiliate her because they had a history of conflict somehow. And the case doesn't explain what that history was, but he was going to make her, he was going to humiliate her, make her go to jail. So Atwater wants the court to draw a line, Justice Souter says, and we're not going to draw this line, but she wants them to say, well, you can jail somebody, you put somebody in jail for a misdemeanor warrantless arrest, only if that crime is jailable and fine only. So Justice Souter says, well, an officer on the street may not know what is a crime that's only a fine, or may not know that what this crime is only a jailable offense. But you can't expect police officers to know what the punishment is for every single crime they may see committed. Police officers have to know that this is a crime and I can arrest them for probable cause, but they do not have to know what the punishment is. That's what he's saying here. They do not have to know what the punishment is for a jailable offense. And Justice Souter said you can't expect police officers to draw a conclusion on a moment's notice about what punishment is for the offense. So he talks about, well, marijuana possession. And if the law says marijuana possession is a crime, if you have a gram or more, you can put them in jail. But if you have a less than a gram, then they only get punished with a fine. we cannot expect the police to know that because they're looking at the marijuana. They don't have a scale out there to measure what it weighs. You can't expect the police to know if this amount of marijuana is a jailable offense or just a fine. That's not practical or practicable. That's what he said. It's not practicable. Meaning, in reality, the police, if we decided what Atwater wants us to decide, the police, it's just not in practice, it couldn't work. And so a lot of times the Supreme Court will say, we want to do things that can actually work in real live situations where the police have to make decisions very quickly. And the police cannot be expected to look at marijuana and say, oh, well, this weighs, 4.5 grams or, 0.3 grams. That's not going to work in practice. And he says, we're not overrunning this country with an epidemic of unnecessary minor offense arrests. In other words, this is a specific case. Yeah, the officer shouldn't have arrested her. He used poor judgment. He humiliated her. Yeah, but it was legal, basically. So he says, because there was probable cause and this officer saw her commit the crime, the minor crime of not wearing a seatbelt. When he sees that, and state law prohibits it, that's a legal arrest, and that doesn't violate the Fourth Amendment. So there's no dispute, he says, that Officer Turek had probable cause to arrest. So there's no need for the balancing test. Because once you have probable cause to arrest, you can make an arrest. And the arrest and booking were inconvenient for Atwater and embarrassing, but they were not so extraordinary to violate the Fourth Amendment. It's not a Fourth Amendment violation because she was arrested and booked legally, but he shouldn't have done that. So this is an interesting case about what the police can do if they have probable cause. So, there's one thing, police can do this, but there's another thing, should they do it, right? Because police want the public to respect. Because if the public does not respect the police, can you imagine what this woman is walking around and talking about the police in this town? She's talking a lot of shit about the police, right? A bunch of jerks and assholes. So if people in the community think the police are not trustworthy and they'll humiliate you and they'll arrest you for just not wearing a seatbelt and get you booked and all that. We talk about something called procedural justice. Does anybody know what procedural justice is? You ever heard of that concept? Procedural justice. Procedural justice means when you have an interaction with the police, do you think it's fair or not? If you have an interaction with the police and you don't think it's fair, then they've done research on this. And if you have an interaction with police and you do not think police treat you fairly, then your attitudes toward the police are going to be very negative. And you're going to say the police do not have legitimacy. And if people walk around saying the police treat you unfairly and they don't have legitimacy, they're less likely to report a crime. They're less likely to cooperate with the police if they see a crime. They're less likely to deal with the police in a lot of different situations. So if you have police that are disrespected in the community, they think the police are not legitimate, they won't help the police if a crime occurs. Police investigate crimes, But the only way the police really solve crimes is when people in the community talk to them. Rarely do the police solve a crime if they don't have a source in the community that gives them information that this person is a suspect. So the police need procedural justice. Police need the people in the community to think they're being treated fairly. And one of the big problems in what we call over-policing, especially in minority neighborhoods, Black and Latino neighborhoods, low-income neighborhoods, we have what's called the enforcement effect. We over-police some of these neighborhoods. And so our prisons and jails are filled with minorities and low-income people. Why? Because that's where the police are. That's where they make arrests. The police are not patrolling and arresting people in my neighborhood in the Woodlands. They don't go there. So there's very few neighbors or people in my neck of the woods, as they say. We don't have an over enforcement effect. And studies show white people use more drugs than anybody else in society. But yet our jails and prisons are full of minorities for drug crimes. They're not full of white people who actually use more drugs. Yeah.
Doesn't that imply that the police stimulate the crime rates?
Police what?
Stimulate the crime rates.
Yeah, that's what we call the enforcement effect. The reason that police have, or the reason that wherever the police go is where they make the arrests.
Right.
So yeah, the police activity determines who's in jail.
But what determines police activity?
Where the society wants them to enforce the law.
Okay.
Police have enormous discretion on where they go
They do.
to look for crime. And this is a problem that has existed the whole history of the country, is that police are more likely to patrol and investigate certain kinds of crimes. They call them the crimes in the streets versus the crimes in the suites. Have you heard that? The crimes in the suites, S-U-I-T-E-S, are white collar crimes. We have no concern whatsoever in the criminal justice system with white collar crimes. I could steal $5 million on my computer and get away with it very easily. The crimes in the streets, they're enforced very strictly. I can steal $1 million in a suite crime. It's not enforced. Somebody can steal $10 from a convenience store. That's enforced. Street crimes are where we put the activity. Society has made the decision not to investigate white collar crime. Very, very few investigations deal white collar. The financial crisis of 2008, where the economy collapsed and the government had to spend trillions of dollars to keep us from going under as a country, economically, not a single person was prosecuted for that. Not a single person. And the reason that happened is because stock traders and big, important lawyers were manipulating and actually violating security laws by packaging mortgage securities together It's complicated. And selling those, trading those on the stock market. So they would package a bunch of mortgage securities, which is like your mortgages, and they would sell them and trade them. But those mortgage securities weren't worth anything. So when the chickens came home to roost, and that was discovered, the bottom just fell out of the stock market and trillions of dollars were lost. After in the financial crisis of 2008, people that were going to retire in 2009 had to work another 10 years just to have enough money in the retirement fund. Millions of people were in that situation. Those sweet crimes, we don't even have an FBI category that categorizes white collar crimes. The only thing we collect are street crimes. But I can make an argument that much more money is stolen. I mean, it's not even, it's 1,000 to 1. It's probably even 10,000 to 1. The street crimes, but that's what we focus on instead of crimes in the suites. Okay, we'll pick it up. Whatever the next case is on the syllabus,